Okay, well, I make it 4 o'clock, so we'll now start the webinar. So I just wanted to say a really warm welcome to everyone and thank you very much for taking time out today to attend the Parker Bullen webinar on intellectual property. So I hope you're all well, having a good Thursday. It's great to see so many of you supporting us and attending, which is now the webinar, which is our 4th webinar in our Parker Bullen 20 in 2020 series. So my name's Molly and I am a trainee solicitor in the commercial department at Parker Bullen, and I will be your host for this short webinar. Effectively, my job is to push the right buttons, ask any questions to the hosts that you may have, and generally keep everything on track. So the way that this is going to work, it's going to be an informal chatty style webinar, so please do get involved. Please feel free to ask questions, which will be you can do using the Q&A button at the bottom of the screen. We will try and cover as many questions as we can. Obviously, we want to give you the best experience in the webinar that we're able to. Sorry, I think we just got some noise disruption there. Before we begin the webinar, and I'll hand over to today's presenters, I just wanted to talk through some housekeeping. So it is intended, as per the name, that this webinar will last approximately 20 minutes, but depending on how many questions that people have, it may run up to 30 minutes. Just to make you all aware that this webinar is being recorded, so it will be shared afterwards on YouTube and on the Parker Bullen website, and a link will also be sent to all attendees at the end of the webinar. We will also be sharing a summary handout which will summarise the information that the presenters talked through today, which you are all going to be able to refer to. So the purpose of this webinar is for us to share with you some useful information, some practical tips, and some guidance on the topic of intellectual property. So as a disclaimer, any advice that's given by the presenters today is generic and it shouldn't be relied upon unless you have spoken to us separately and we've provided you with advice that is pertinent to your individual circumstances. So in today's webinar, as I said, we'll be talking about intellectual property, and I'd like to hand over to today's presenters, who are Hannah Abbott and Luke Wilkins, who are both trainee solicitors at Parker Bullen. So over to you, Hannah and Luke.
Hi, welcome everyone to our webinar. Today we'll be talking to you about intellectual property. We're going to start off just by describing what intellectual property actually is, so just to give you a broad overview of what it means. Then we're going to talk through the different categories of intellectual property. When we're talking through those categories, the intention is that you're thinking about, in your business or personally, what do you own or what do you have which actually falls into these different categories. So it will become more clear as we go through. You might think, oh, actually that relates to this that I have or this in my business, and I might want to look further into that. And then finally, we're going to go through what you might consider when you're looking into intellectual property, for how you might manage and exploit that intellectual property. So let's start then by just describing what intellectual property is. So intellectual property is a form of intangible property. It is not a car that you can drive down the street. It is something that you don't even know exists. It's not there, you can't see it. However, it does entitle you to certain things. It entitles you, firstly, to stop other people from copying or using your ideas, designs, inventions. This clearly is really useful. Now, when you protect those things, it's protecting the things which are in your mind, things that you can create. You might express them on paper, but really it's started in your mind. The first of the categories that we're going to talk through is copyright. And I'll hand over to Hannah now to talk you through that one.
Hello, thank you, Luke. So the first category we're going to discuss today is copyright protection. Quite simply, copyright protection protects a form of expression in creative works, be that literature, music, artworks. The owner of the copyright is traditionally the author of the work. I mean, there are some variations to this, but that is the common rule. Examples of copyright in a modern context. So if you have a song, and it is used in a YouTube video, you would need to get the author's permission to be able to play that. Otherwise, you might be at risk of infringing that copyright. The copyright does not provide a monopoly in the same way that other IP rights do, and it does not require registration. So copyright subsists in the work upon creation. And that is an overview of the copyright. And I'll pass you back to Luke to quickly describe design rights.
Thank you. So design rights, they're a little bit more complicated in the fact that you have both registered and unregistered design rights. And these two are actually really quite different. Their intention is to protect your 2D and 3D designs. So you might have a design on paper with measurements and shapes and sizes and things, or you might have a 3D model of something. These design rights are designed to protect those from being copies or from being utilized by other people. Now, clearly, if you have a design like that, that can be really useful and you can really exploit that. And actually, relatively, this has quite a low cost of registration if you decide that registering is what you would like to do. What you really need to think about is whether registered or unregistered designs are more appropriate for your design in particular. Back to Hannah.
So the next category that we're going to look at are trademarks. This might be the category that we are most familiar with as we see them on a daily basis. If you take a look at the bottom right hand side of the slide, you'll see some very, very famous logos that are protected by the trademarks. I'd be surprised if anyone can't get 4 out of 4 in guessing which company those relate to. So that just shows how important protecting these are. It's a crucial part of any brand. As it distinguishes the goods and the services from one trader to another. So any sign that is represented graphically and is capable of distinguishing goods and services can be registered as a trademark. There are 2 types of trademarks, similarly to design rights. You can have an unregistered trademark or you can have a registered trademark. Unregistered trademarks can still be used to help the owner commence proceedings against someone who is using it illegally. However, this hinges on a common law principle, and it is more difficult and possibly more expensive in the long run to explore the options there. However, if you do register your trademark, it is then therefore easier to take legal action. Obviously, registration does come with fees, so it is important to weigh up the fees associated with registering a trademark versus the expense of possibly having an unregistered trademark that you would therefore need to enforce after that. And that is trademarks for you. I'll pass you back to Luke.
Thank you. Finally, as our last category, we're going to talk a little bit about patents. Patents are what protects inventions. So when we talk about patents, what we're really talking about is things in technology, things in medicine, things that take a lot of thought and time and processes to develop over a long period of time. There's a lot of R&D will end up in registering for a patent. So there are a couple of things that you have to do to qualify for a patent. Your new invention, it must be new, it must constitute an inventive step, and this can kind of seem a bit similar to new, but it's really not. So you could have a commonly used drug such as paracetamol, and you could add sugar to it. Well, that might be a new drug, but it's not an inventive step. It doesn't progress the invention at all. It also has to be capable of industrial application. Now, that industrial application is obviously not just used in industry, but it can be quite broadly interpreted to be used in lots of different areas. And also, it has to not be excluded through any of the legislation. With patents, registration is required. It's really important that you get registration, because obviously as soon as your invention goes out there, anyone can tap into it and use it. And that's why when you see technology companies and medicines companies, R&D, they will all go out and file for loads of different patents to protect themselves. So that's really important for those types of companies. We're now going to look at some other general considerations that you might want to look into.
So after you've assessed the types of intellectual property you and your business might have, it's really important to consider the following. So confidential information, maintaining confidential information can be crucial to a business, especially during like a patent application, where one of the prerequisites is that the invention can't have been broadcast publicly, so you have to be the sole owner of that IP. So a company may wish to enter into a confidentiality agreement or a non-disclosure agreement to help manage this. Another consideration is to do with licensing. So as an owner of the intellectual property, there are certain exclusive rights over this work. An owner may wish to exploit this and create a license or grant permission for a third party to use this for their own commercial gain, and that can be really effective in the business environment. Another avenue that you might want to consider is franchising. So a business may allow a third party to use its intellectual property, such as name, its concept, and its brand. This may be done by a franchise agreement. So examples of really popular franchises, I didn't even realize were franchises, include the pizza chain Domino's, the jewelry shop Pandora, and Starbucks is also a franchise. And then the final consideration to think about when considering your own IP is the international aspect. So IP rights are jurisdictional, which means that you'll need to consider different jurisdictions. Let's say if you registered an idea here in the UK and then wanted to go and proceed with business in the US or Asia, you might have to register the idea separately in order for it to still be valid in those different jurisdictions. So those are some considerations that you would really seriously need to consider. Thank you. I'll pass you back to Luke.
So there we've gone through the different categories, IP rights that you might want to look at and really think about, does this apply to me? So this is the step one on the slide that we've got here. So identify, what IP does your business have? I've got here a suggestion, a logo. So I have a logo. How do I then go to step two? Protect. How do I protect that logo? How can I protect other IP within my business? Do I need to register it, or is it already protected? Is it something that falls under copyright, which is an unregistered right? Or is it something that's like a patent and needs to be definitely registered? Once you've identified all of your intellectual property and you've then protected it, well, it doesn't stop there, of course. You have to then manage your IP. You have to figure out, am I exploiting my intellectual property to the full extent that it can be? I'll take the example of a logo again. There's no point in having a protected logo if it's not on your van that drives around, if it's not on all the paperwork that you send out, if it's not stuck on the front of your shop so that everyone knows who you are and that that logo is attached to you. So these are the types of things that you really need to be thinking about. Have I identified all of the intellectual property? Have I protected it all? And am I exploiting it efficiently? And that, I think, is all we've got for you. So I think Molly's going to go through the questions with us now, but thank you very much for coming. And here is the page with our contact details. Thank you.
Thank you very much, Luke and Hannah, for a very informative and engaging webinar. If anyone would like to ask any questions, please do use the Q&A facility, which you'll find at the bottom of your screen. We do have a couple of questions coming in for you both. So we've got a question from Jenny, who says, I have not registered my company logo as a trademark, but I have included the TM mark after it on my website. Is this allowed?
I can take that one if you're happy with that, Luke.
Yeah, go for it.
Commonly the TM logo indicates that the preceding mark is in fact an unregistered trademark. So therefore it is completely legal and okay for you to use this on your website and any other company literature, etc. However, the flip side of that is that this could indicate that the mark is not registered, and could therefore mean that your competitors would see that and try to register it under a different category or class. Your options here would be to either remove the TM sticker completely or register the trademark, in which case you would then have the legal right to insert the little R symbol, and that would deter your competitors from using your mark, and it protects your trademark in the future.
Thank you, Hannah. That was a really great answer. And we have had a question come in from Susan. And thank you, Susan, who said that she's found the webinar very interesting. So thank you very much for that. Susan's just asked, can we give a gauge as to pricing for the registration of a trademark? I was wondering if possibly, Susan, we should we will be able to email you if you drop us in the chat box your email address. Possibly if we'll send you a little email after the webinar just detailing our pricing structure and what we'd be able to offer. Does that sound okay? Okay. So we do have another question from Sean, who asks, my business has a logo and a strap line. How can we protect both of those?
I'll take this one. So if you have a logo and a strap line, actually, by virtue of it being a creation of your own and an image, and also possibly a literary work, it could possibly fall under copyright protection. But what you would more likely look at is actually trademark protection, because your logo and your strap line is actually the thing that differentiates your services from those of other traders. So what you would want to do is you'd want to look into getting a trademark application through so that it's registered. But that's not the only thing to consider. Like I said earlier, once you've protected that, that's not the end of the story. You then need to make sure that you're making the most out of the money that you spent in registering that mark, and you're actually getting that out there, and you're making sure that customers do associate that strapline and that mark with you, so that if you showed that to a random, someone on the street, they could say, oh yeah, that's my mark. So I hope that helps.
Much, Luke, for your brilliant answer on that. Does anyone else have from the audience have any other questions to ask Luke and Hannah in regards to either the contents of the webinar or potentially what Parker Bullen will be able to help you with in relation to protecting your IP? Please feel free, as I said, to chat to put a question in the Q&A box. We'll just wait for a few moments for that to come through. Okay, so if no one has any more questions, I think that concludes the webinar. So I'd just like to say a huge thank you to everyone for attending today. As a firm, we really, really appreciate the support and you all taking time out of your busy days to come and support us. A huge thank you to Luke and Luke and Hannah for your excellent presentation today. Really is appreciated. As I've said, we will be sending you a link to the recording and a summary handout at the end of the webinar. And if you've had any queries about anything that's been discussed in today's webinar, or if you would like any tailored advice on any of the topics covered, please do not hesitate to get in touch. We've got all our details on the screen, so Hannah and Luke's emails, also our telephone numbers, and we would love to hear from you, even if it's just an inquiry as to what we might be able to do for you. We'd love to hear from you, and it's just to say thank you everyone for attending, and I hope you have a lovely rest of your day. Thank you.
Thanks everyone.
Thank you.